Property division would occur in a divorce when the parties have accumulated property together. The property division can be settled either in court at the time of trial if the parties can't come to an agreement, or by mediation, or by an agreement between the parties. Property division encompasses all forms of assets, whether they are tangible or intangible. For example, the obvious would be tangible, such as a home or furniture, but the intangible would be more of, for instance, frequent flyer miles that someone has accumulated, or even sick time or vacation time that they've acquired through their employer. California is a community property state, which means that anything acquired or any assets acquired during the marriage is to be divided 50-50. An exception to community property is when someone receives an asset during the marriage by either a gift or by inheritance. If a person receives such an item, it's considered the sole property of the person who receives it. Another way to deviate from community property laws of California is to enter into a prenuptial agreement. A prenuptial agreement is a contract between the parties made before they marry that states that the community property laws or some of the community property laws won't apply to their marriage. One of the provisions they can include is how the division of assets acquired during the marriage will be different than what the normal community property laws require. The division of community property is very complicated and complex. You should hire an experienced family law attorney to handle the division of your property. Otherwise, you run the risk of losing property you may be entitled to. In my 8 years of experience practicing solely family law, I've handled hundreds of matters regarding division of property.